Happy New Year, everybody. We are back on the Hoplite channel. It is January 1st, 2024, and 2 days ago I noticed something hit the news, and we are here to cover it for this fourth part 2, FTX and the USA, the scandal of scandals. It just won't go away, right? It's like that bad penny that keeps showing up, the FTX and the US scandal. Yeah. Well, as you saw from the opening card there, the U.S. Department of Justice has decided 2 days before the new year, by the way, to not pursue a second trial against Sam Bankman-Fried. And the second trial would be for what they call additional charges. But let's run through the timeline real quick and get up to speed. For anybody who's new here, who maybe had seen the first 3 parts, but I recommend you go back and watch, because yeah, this is the scandal of scandals, and I keep calling it that because it is. Like, it should infuriate anybody, regardless of where you fall on the political spectrum. But let's go back to when this case started against Sam Bankman-Fried, the previous CEO of the now defunct FTX cryptocurrency exchange. July 27th of last year, 2023, a couple months ago, the U.S. attorney agreed to drop the campaign finance fraud charges that were being brought in this case against SBF. And everyone, including myself, said, well, there you go, right? In my first episode part about this scandal, I was saying that, yeah, FTX was used as a vehicle to launder U.S. taxpayer dollars back from Ukraine to U.S. politicians for the 2022 midterm elections. And that's exactly what it was used for. The other cryptocurrency exchange that was in competition with FTX, Binance, a man by the name of Changpeng Zhao, or CZ as he's known, pulled the rug on the Ponzi scheme that was FTX, and it imploded as a result. And it imploded right before the midterm elections, but it imploded close enough that people were still able to keep their ill-gotten gains. And it looks like now, based upon the DOJ's decision in December of last year, literally 2 days ago, they told the court they're not going to pursue the campaign finance fraud charges in a second trial. Yeah, we don't need to relitigate that. So yeah, he was found guilty the previous month, November, and part 3, I covered that, on 7 charges. And he's scheduled to go to sentencing in March. So in 3 months, Sam Bankman-Fried will find out what his fate will be. He faces up to 100 years, so chances are they're going to just bury this guy in prison and be done with him because they got what they wanted out of it. But let's go and back and read the letter from the U.S. Department of Justice to the judge in this case as to what the rationale would be for not pursuing this second trial. And I'll put it up for you to read as I go. So, December 29th, the letter went out and the decision came thereafter. To the Honorable Lewis Kaplan, U.S. District Judge, Patrick Moynihan Building, U.S. Courthouse, New York, New York. Interesting that this case, by the way, was filed in the Southern District of New York. But, yep, that's where it went. Judge Kaplan, the government respectfully submits this letter to provide notice to the court and the defendant that it does not plan to proceed with a second trial in the above captioned matter. As explained below, much of the evidence that would be offered in a second trial was already offered in the first trial and can be considered by the court at the defendant's March 2024 sentencing. Given that practical reality and the strong public interest in a prompt resolution of the matter, the government intends to proceed to sentencing on the counts for which the defendant was convicted at trial. On December 9th of 2022, a grand jury returned indictment 22 CR 673. Counts 1 through 7 charged the defendant with 2 counts of conspiracy to commit wire fraud, 2 counts of wire fraud, conspiracy to commit commodities fraud, conspiracy to commit securities fraud, and conspiracy to commit money laundering. Count 8 of the original indictment charged the defendant with a conspiracy to make unlawful campaign contributions. The defendant was extradited by the Bahamas in December of 2022, but in July of 23, the Bahamas informed the U.S. that it had not included consent to the trial on Count 8. Thus, the government was prevented from proceeding to trial on Count 8 due to its binding treaty obligations with the Bahamas. At trial, however, the government offered evidence of the defendant's scheme to make unlawful campaign contributions, both as direct evidence of the other 7 counts and pursuant to Federal Rule of Evidence 404B. The defendant was convicted on all counts. And because the government also proved that the defendant engaged in a scheme to make unlawful campaign contributions, the court may consider the scheme as relevant conduct at the defendant's sentencing. On March 28, 23, the grand jury returned superseding indictment S522CR 673, which include 5 additional counts, the additional counts, quote unquote. The additional counts charged the defendant with conspiracy to bribe foreign officials, conspiracy to commit bank fraud, conspiracy to operate an unlicensed money transmitting business, and substantive securities fraud and commodities fraud. At the trial, the government introduced evidence of the defendant's conduct underlying the additional counts, either as direct evidence pursuant to 404B. The evidence at trial, including witness testimony and documentary evidence, proved that the defendant engaged in a conspiracy to bribe Chinese officials, that he made false statements to a U.S. bank to induce it to open a bank account that he used in furtherance of his other fraudulent schemes, that he conspired to operate an unlicensed money transmitting business, and that he committed substantive securities fraud and commodities fraud. The court may also consider evidence of the defendant's commission of these crimes at his sentencing. After obtaining the superseding indictment, the United States sent a request to the Bahamas for a waiver of the rule of speciality to permit trial on the additional counts. However, the defendant moved to intervene in the extradition process in the Bahamas, delaying the process. Accordingly, the government consented to the court's severance of the additional counts and proceeded to trial on the 7 counts for which the defendant was originally extradited. To date, the Bahamas has not agreed to waive the rule of speciality, and the government does not have a timeline for when the Bahamas may respond to the request. Nonetheless, as described above, the government proved at trial the conduct underlying the additional counts. Indeed, trial on the additional counts would feature much of the same evidence that was presented at the initial trial. And importantly, a second trial would not affect the United States sentencing guidelines range for the defendant, because the court can already consider all of this conduct as relevant conduct when sentencing him for the counts that he was found guilty at the initial trial. Accordingly, the government does not intend to proceed to trial on the additional counts. Proceeding with sentencing in March 2024 without the delay that would be caused by a second trial would advance the public's interest in a timely and just resolution of the case, as delay in sentencing may leave the defendant, as well as the victim, in limbo concerning the consequences of conviction. U.S. v. Ray. The interest in avoiding delay weighs particularly heavily here, where the judgment will likely include orders of forfeiture and restitution for the victims of the defendant's crimes. The government has concluded that the public interest in a prompt resolution of this matter outweighs the interest in holding a separate trial. Respectfully, Damian Williams, U.S. Attorney, and extra people. Okay, so there you have it. The United States government, for probably one of a handful of times that can be remembered, is deciding not to pursue another trial against somebody who has previously been convicted for a slew of federal charges. Does anybody really believe this? Like, as I said in part 3, if you again watched it, their excuse is, well, the Bahamians turned him over, but they didn't turn him over with the campaign finance charges in mind. We forgot to include that. That was our bad, right? We're the US DOJ. I mean, we always get our man, and we got Sam Bankman-Fried, but the people who turned him over didn't know we were going to charge him with campaign finance fraud. And they haven't gotten back to us yet. And, well, you know, it's in the public's interest that we move this along. Because, you know, there's restitution and stuff, and they'll be in limbo if we don't. And so, you know, the Bahamians, you know, have a treaty with us, and we have to honor that. Yeah, that's the bullcrap excuse that they're still shoveling, is that well, treaty with Bahamas, yeah, man. We really dropped the ball, and we're sorry about that. But let's get this behind us. We don't need to go to a second trial. The additional counts, we already proved that in the first trial, technically. So yeah, except you didn't, right? The reason these counts are additional is because they weren't included in the first trial. You would have to go through an entirely new set of discovery for what these charges would entail. And the DOJ just doesn't want to do that because the people who benefited from the FTX Ponzi scheme were most likely senators and congresspeople and possibly presidents, and we can't have that coming out into the public. So we're not going to open the door to it. And I think this is what probably Sam Bankman-Fried's lawyers should probably appeal on. And he should say, well, Your Honor, like our client, he obviously is devastated by these charges, but we feel that these additional counts need to be brought before a jury and need to be given their due process, because what if it turns out that people that our client relied on set him up for this? What do we say about those people? These powerful people who may have used our client. Our poor little boy here, Sam. Sammy didn't know what he was doing. He was all caught up in this. He was just getting money thrown at him. It was the people in the U.S. government who leveraged him and are now making him the patsy. That should be what hopefully that's what the appeal will be. But it just goes to show you the hypocrisy of the U.S. Department of Justice saying, well, we already litigated something once. We don't have to go through it again, right? When have you ever seen the Department of Justice do something out of expediency or do something in the interest of the public having closure? It's like they will literally go after you for defrauding the IRS for $5. And this guy defrauded scores of people for hundreds of millions of dollars. And yeah, Damian Williams and company think that it's not really worth the time for the DOJ, and certainly not worth your time, Your Honor. So we're not going to bother with it, yeah. But let's jump to a different case and why the DOJ is singing a different tune for these individuals who arguably committed far less of a grievous offense than Sam Bankman-Fried. And I'm talking in particular to the January 6th rioters. You'll know them as the Proud Boys. And we see that there were multiple individuals, the Proud Boy leadership, quote unquote, some of whom weren't even in Washington, D.C. on January 6th, who were handed 15 to 20-year sentences by a judge for essentially disrupting an official government proceeding and criminal trespass. Now, the question is, okay, but the DOJ won that case too. They're appealing it. And allegedly, they're appealing it because they don't feel the judge handed down long enough sentences. The DOJ wins the case, gets these poor guys sentenced to up to 2 decades of their life in prison for what would, on any other day, have been misdemeanor trespass, and they're going to appeal their win because they didn't get the sentence they wanted. But in Sam Bankman-Fried's case, defrauding thousands of people for hundreds of millions of dollars, yeah, it's not worth a second trial. Let's read the next article about this case down here. This is from the Washington Post. This is from October 17th of last year. And it's titled, U.S. to appeal sentences of 5 Proud Boys in Jan 6 Capitol riot case. Prison terms were among the longest for Jan 6 defendants, but far below government recommendations, by Tom Jackman. Begins. The government filed notice Monday that it was appealing the sentences of 5 members of the far-right Proud Boys group convicted in January 6, the attack. The second such unusual notice by federal prosecutors after a similar filing in July, indicating they would challenge the punishments handed down to 5 members of the Oath Keepers for their role in the Capitol riot. In both cases, the prosecutors were not required to file an explanation for their initial notices, but both cases could reflect government dissatisfaction with the length of the sentences, even though the Proud Boys' former leader Henry Enrique Tarrio received the longest sentence yet imposed for the Jan 6 Capitol riot, and 3 other members received more than 15 years in prison. A spokeswoman for the U.S. Attorney's Office said the filing merely preserves our ability to appeal, though the government typically does not appeal sentences after they are imposed. The seditious conspiracy convictions of Tarrio and the Oath Keepers founder Stuart Rhodes were among the most high-profile prosecutions for the Justice Department's sprawling Jan 6 investigation that targeted organized far-right groups, and more than 1,000 others who attacked the Capitol's Congress met to confirm the 2020 Electoral College results. In both cases, the judges imposed sentences well below those recommended by the federal sentencing guidelines, which are only advisory. The prosecution's practice in most Jan 6 sentencing has been to calculate the guideline range, which combines a defendant's criminal history and the seriousness of the offense, and then proposes a sentence in the middle of that range. The judge then calculate their own guideline range and can go within or without or below that range. In more than 60% of the Jan 6 felony cases, the D.C. judges have gone below their own calculated guideline range and below the prosecution's sentencing recommendations in 80% of all cases, according to a Washington Post database. The sentencing guidelines are not used in most misdemeanor cases. In the Proud Boys case, prosecutors calculated Tarrio, the leader of the group, should have a sentencing range of 30 years to life and recommended a term of 33 years. But U.S. District Judge Timothy Kelly, a Trump appointee, by the way, calculated Tarrio's range at 27 to 34 years in prison and then gave him a sentence of 22 years. Judges are not required to explain why they deviate from the guidelines, as they were when the guidelines were mandatory. The Supreme Court made the guidelines advisory in 2005. Kelly acted similarly with 4 convicted Proud Boy members. Prosecutors sought a term of 33 years for Joseph Biggs, who was on the front lines of the January 6 attack, and Kelly sentenced him to 17 years. Prosecutors sought 27 years for Ethan Nordine. Kelly gave him 18. Prosecutors sought 30 years and 20 years for Zachary Rell and Dominic Pizzola. Kelly imposed terms of 15 and 10 respectively. Nordine's 18-year sentence equaled the term given to Rhodes, the second longest January 6 sentence after Tarrio. Biggs and Reel's terms are the longest of the more than 650 sentences handed down to January 6 defendants so far. We look forward to reviewing whatever the government intends to file as a basis for their appeal, says Naib Hassan, one of Tarrio's lawyers. Hassan added, "We are tediously working on the issues of Tarrio's appeal and believe we will prevail on multiple grounds." Attorney Norman Pattis, who represented Rell and Biggs at their sentencing, said in an email after the notice was filed, "Merrick Garland is unhinged, period. Call him the Inspector Javert of the DOJ. He should take up bungee jumping. This is no longer my government." Nicholas Smith, Nordine's lawyer, said in an email that his client is encouraged by the government's agreement that errors led to the judgment and sentence in his case. Roger Roots, an attorney for Pizzola, called the intended appeal an outrageous abuse of power. "These are already the longest sentences in American history for participating in a political demonstration," Roots said in a statement. "Congress was only delayed for 6 hours on Jan 6. The DOJ is really engaging in overkill." Okay. So yeah, there you have that. There's that story, right? You've got these guys who were at the Capitol on January 6th. Some of them entered the Capitol. And as I said, Tarrio, whose picture I'll put up here, wasn't even, I believe he wasn't even in Washington, D.C. on January 6th. I'm not sure what state he was in, but he wasn't even in the District of Columbia, and they still got him somehow for 22 years, right? Now, think about like all the times you've seen on TV, the news, like there's some there's some Senate hearing or some congressional oversight committee on, spending money on the war or the border or what have you, and somebody or group of people stands up and starts shouting, and they start, holding posters that they made at home. Like if you're old as I am, remember Code Pink? These like lovely spinster ladies during the Bush administration would constantly crash these Senate hearings or congressional committee hearings that were open to the public and start shouting at U.S. Cabinet members or Condoleezza Rice or Colin Powell or whoever, and they would make a ruckus. They'd make a big commotion, and they'd just get ushered out of the room and told to buzz off. To my knowledge, not one of those women was ever charged with disrupting a official government proceeding or anything of that nature. And we still know that on January 6th, the only person who lost their life was Ashley Babbitt. We know that, right? And she was shot by a Capitol police officer, and he wasn't even in. I think they scoped him and investigated him, and brought no charges. Not even like reckless endangerment. I mean, nobody was armed in that group of people, and he shot her through the neck. But these guys are going to jail for, some of them, 2 decades or more, and the U.S. Department of Justice is going to appeal those sentences because they're not long enough. But when it comes to Sam Bankman-Fried, who probably ruined a lot of people's lives, probably bankrupted them, they're not going to bother with a second trial for the campaign finance fraud charges because of the names of the people that might come up in those proceedings. The names of those people are the same names that are probably telling the DOJ, go back and try to get a longer sentence for these guys because they, dared threaten us. And now we see there is an effort now among Colorado and Maine for the time being to remove former President Donald Trump from the ballot based upon literally nothing. There have been no criminal charges brought against him that would warrant taking someone's name off of a ballot, as in they're a convicted felon. They're just removing him. Like the Colorado Supreme Court decided based upon nothing. I think Lieutenant Governor, I don't even know what her name is, never seen her before. She just said, sedition, conspiracy, insurrection, blah, blah, blah. Trump's not going to be on the Maine ballot. Folks, I know I try to ride, the libertarian rail as best I can with this channel, because I could go on for, hours just on politics. But this is insane. And I wanted to do this video on the first day of 2024 because this will be an election year. And everybody knows that 2020 was the most contested election in modern American history. Nothing comes even close. And there are still serious doubts as to the legitimacy of that election. And I have several of them. And now that they are trying to ruin these guys who showed up in DC to peacefully protest legitimately, to my knowledge, nobody has been federally charged with any acts of terror or organized crime for the riots that happened in DC during the summer of 2020. But the DOJ, if they had their druthers, they would put all of these Proud Boy guys away for life. And literally, they stole nothing, they destroyed nothing, and they assaulted no one. And the DOJ, your government, wants them in jail forever. It's because your government dislikes you. Your government probably hates you. And the people distrust their government. That's what's going on. There's 2 Americas right now. And the people in the government right now despise challenges to their power. And this is what they do with people who are foolish enough to challenge them openly. And love him or hate him, Donald Trump is still the biggest threat to that power structure. He was the biggest threat in 2016. They underestimated him. And when he won in 2016, they told themselves they weren't going to be caught flat-footed ever again like that. And now it looks like they might just try to remove him from enough states' ballots where even if he does run, he won't be able to win the Electoral College because of the deficit between states that list his opponent, whether it be Joe Biden or whoever, and him. And it's an egregious slap in the face to the people of this country who still believe in our democracy. It is an existential threat to our democracy to literally take the most popular person right now in the polls and eliminate him from a ballot, and there's been no due process for it. This is how democracies eventually devolve into civil wars. This is how it happens. When people no longer have faith in a system, right? A system that lets an exchange like FTX and a guy like Sam Bankman-Fried build up this massive Ponzi scheme right under the noses of the Securities and Exchange Commission, right under the nose of the FBI, the DOJ. And then when the money laundering is all done, they sweep this guy under the rug as fast as they can. And when the campaign finance stuff comes up, yeah, we don't need to do that, right? We already litigated most of that anyway. But these people who didn't even steal $1 million, let alone $100 million, they want these people to rot in jail until they die. And that's the way your government looks at you. You can do all of this as long as you're playing the game and they get to wet their beak. If you get caught and bad things happen, well, they'll dispose of you. But these people, they want to literally grind them underfoot. And this is going, again, I feel like it's like 2020 all over again. And while it might not be a pandemic that is the number one news story, something else is going to happen. And there's these movies coming out now that, like, the Obamas, promoted this movie. I think how a former president who literally had no previous work history except he worked in the Senate has enough money to produce a movie. I don't know. It's like, okay, I guess Barack Obama and Michelle Obama now have money to produce movies. And Leave the World Behind, I guess, is that name of the movie. I'm not going to watch it because it's just I don't like play that game where I would just like buy into the predictive programming. And they have another movie coming out, I guess, in April called Civil War. So it's almost like they're rubbing your face in it, like they're going to tell you what you're probably going to do or what's going to happen before it happens, and they think it's a joke. They think you're a joke. This stuff angers me, and it should anger you too. That something like FTX happens, and they try to sweep it under the rug, but then these people, whether you agree with them politically or not, they're trying to literally put them in jail next to convicted serial killers, people who have murdered multiple other people. They want these guys to be seen as the same as that, to be seen as killers, to be seen as bank robbers, to be seen as international terrorists. That's what they're trying to do. But this guy, SBF, he was just the mule, and now they're putting him out to pasture. So we'll see what happens to him in March, and then we'll have the election at the end of this year in November, or maybe we won't. Who knows? But if you agree or disagree with any of this, put in the comments. Again, as I said in the opening, Happy New Year, and I think 2024 is going to be a wild ride. So put your helmet on and fasten your seatbelt. Okay, we'll see you back here next time. Until then, take it easy.